Hello guys, so today we're going to be talking about the case law Fredericks versus California Teachers Association. The issues that this case law brings up is, do unions violate public employees' First Amendment rights through public sector agency shop arrangements or by requiring them to affirmatively object to subsidizing public sector union non-chargeable speech? So what Frederick wants is, because of the political nature of collective bargaining, compelled agency fees are a violation of the First Amendment, and the opt-out system takes advantage of dissenters unaware of the affirmative objection requirement. In opposition, the union argues that there is no justifiable reason to modify the opt-out arrangements and that agency shop arrangements do not infringe employees' First Amendment rights, but are necessary to prevent a free riding problem. Now, should they rule in favor of Fredericks, the decision could provide the right to work protection for all public employees in the country. Right to work, meaning a union cannot get a worker fired for not paying their dues or fees. And it will allow public workers to opt out of their union without needing to renew their objection every year. Currently, many unions require members who opt out to redo their paperwork each year in order to refrain from paying for union politics. So a little bit of legal history here. Agency shops. There are workplaces such as school districts in which full membership of a union is not required of employees, but the union acts as the exclusive representative for all employees in that place of employment. Now, one case that Fredericks uses is Abode versus the Detroit Board of Education, and it involved a group of public school teachers who challenged the constitutional validity of a Michigan state law that allowed the inclusion of agency shop clause in a collective bargaining agreement between the Detroit Federation of Teachers and the Detroit Board of Education. And so what it ruled is that it is valid to compel employees to support an exclusive bargaining representative, and that a union may use funds from non-members for political or ideological causes without non-members' consent. So some facts about this case. California law allows unions to become the exclusive bargaining representative for the public school employees of that district, and therefore have a great deal of influence over a wide range of conditions of employment. Once a union is the exclusive bargaining representative for the school district, it may establish an agency shop agreement, which means that a school district may require a public school employee to either join the union or pay the equivalent of dues to the union in the form of a fair share service fee. Now, because the First Amendment prohibits unions from compelling non-members to support activities that are not exclusively devoted to negotiations, contract administration, and other duties as an exclusive bargaining representative, unions must send notices to all non-members laying out the breakdown of the chargeable and non-chargeable portions of the fees. Now, agency fees are limited to activities germane to collective bargaining, which include lobbying activities to aid contract administration and secure and wage hour benefits. Expenses involved in conducting germane activities are chargeable, whereas expenses unrelated to collective bargaining are non-chargeable. So each year, unions must estimate the expenses belonging in each category and send a notice to all non-members. And the non-members who do not wish to pay the non-chargeable portions of the agency fee must affirmatively opt out by notifying the union. The union then sends these objections a rebate for the year. Now, Fredericks and other public school teachers did not wish to be represented by the union that were exclusive bargaining representatives. What her and her fellow plaintiffs argued was that collective bargaining in the public sector is inherently political, and government unions devote more resources to their political agenda than just the small portion of dues which are exempt from agency fees. Because of the political nature of collective bargaining, workers have a First Amendment right to not pay any dues or fees to the union. Now, the United States District Court for the Central District of California granted Fredericks' motion of judgment on the pleading in favor of the opposing party, the union. Fredericks asked the court to grant judgment in favor of the union because her claims were presently foreclosed by Abode versus Detroit Board of Education. Fredericks then appealed to the United States Court of Appeals from the Ninth Court, which affirmed the district court's ruling. So, in conclusion, the decision is affirmed by an equally divided court. It was ruled 4-4 in the Ninth District Court. Now, the application of this. If the justices ruled in favor of Rebecca Fredericks, government workers across the country would not need to pay unions as a condition of employment. Workers in the 25 right-to-work states already have this right, and some government workers in a few non-right-to-work states have similar rights. This means that such a decision would only affect workers in roughly half the states in the country. It's even been explained that in in the right to work states, only about 20% of unionized workers exercise their rights, meaning that unions in these states still have financial support of about 80% of the workers on average. Now, in the past year, they've come out with a new ruling for a different case that is pretty much exactly the same to Fredericks versus California Teachers Association. And in this term, it ruled for the plaintiffs. And so right now, the state of California is currently working to negotiate how this is going to work for the unions. But as of 2016, they ruled in favor of the unions. And as of 2018, they have now switched to in favor of the plaintiffs. So they're currently working out how this is going to go. Thank you for listening, and I hope you enjoyed.